Enacted in 2015, the Administration of Criminal Justice Act is yet to fully get underway due to a number of factors. Of the factors stopping ACJA, two clearly stand out. These are the aspect that requires a case to begin from scratch in the event of the elevation of a judge or his or her death. The second problematic factor is that it doesn't allow sentencing of a criminal suspect who is in hiding or on the run. But the stakeholders seem to have reached a common understanding.
When you look at the constitutional provision where the court can deliver judgment upon final address within 3 months, what if the court finds the accused person and convicts him, but for maybe a year or more than 3 years or 3 months, he is not apprehended or he does not submit himself to the jurisdiction of the court for the purpose of sentencing? So we believe there's a need for an harmony between the two subsections.
Section 3967 is already captured in an amendment which is currently before the National Assembly. Similarly, the observation made in regard to Section 352 sub 4 and 5 is also captured in that amendment to bring that provision in conformity with the Constitution, which says that courts must deliver their judgment within 3 months. So when a judge now takes a case in absentia, the judge will not only be able to convict, the judge will also be able to sentence in absentia.
I'm happy about the SUCO coming through the Senate and as announced by Professor Akinseye George. But before the thing comes, in respect of sentencing, Section 352, you can make use, I agree that it gives a cause for concern, but you can also make use of MLA, and we have been using it. No country will hear MLA, mutual legal assistance.
And the National Assembly too has committed to addressing the inconsistencies in the criminal justice system.
There is a need to amend the Administration of Criminal Justice Act to bring it in tandem with the provision of the Constitution that gives time frame for delivery of judgment, so that the judge cannot only convict but also go ahead and sentence.
The Administration of Criminal Justice Monitoring Committee has the task of preventing abuse of the procedure by ensuring that suspects are detained only in deserving cases, preventing congestion of prisons and decongesting prisons by providing for the release of wrongly imprisoned suspects.
The Administration of Criminal Justice Act 2015 was enacted for the purpose of ensuring that the system of administration of justice in Nigeria promotes efficient management of criminal justice institutions, speedy dispensation of justice, protection of society from crime, and protection of the rights and interests of the suspects.
We aim to contribute to a Nigeria that is safer from drugs, crime, corruption, and terrorism, while also promoting health, justice, rule of law, and building resilient communities.
The Chief Judge of the High Court of the Federal Capital Territory signed the practice direction and guidelines on remand proceedings.
The success of any law does not lie just in its enactment, but in its effective implementation.
The Chief Judge of the FCT High Court is currently the sole chairman of the Administration of Criminal Justice Monitoring Committee, but by the time the National Assembly concludes amendment of the Act, the Chief Judge of the Federal High Court will be a co-chair. Godfrey Eshemoge, Arise News.